The Voting Rights Act of 1965, often called the VRA, stands as a cornerstone of American democracy and civil rights. It was a landmark law that fundamentally changed the way our country approached voting and representation. The act was created to end nearly a century of discriminatory practices, like poll taxes, literacy tests, and intimidation, that systematically kept Black Americans and other minorities from voting, especially in the South. By enforcing the 15th Amendment, the VRA banned these barriers and made the right to vote real for millions who had been excluded. It was a direct response to the courage of civil rights activists who risked everything for equality. One of its most powerful tools, Section 5, required states with histories of discrimination to get federal approval before changing voting laws, a process known as pre-clearance. This helped prevent new forms of voter suppression from taking hold. Section 2 allowed individuals and groups to file lawsuits against any voting practice that discriminated, even if discrimination wasn't openly stated. This gave communities a way to fight back in court. The impact was immediate and profound. Black voter registration and turnout soared, and for the first time, minority communities gained real political power and a voice in government. Recognizing its importance, Congress has renewed and strengthened the law many times over the decades, reflecting its vital role in protecting the integrity of American elections and ensuring every vote counts. Over the years, the VRA has been used to challenge unfair voter ID laws, polling place closures, and racially gerrymandered maps, continuing the fight against new threats to fair voting. Today, it remains the primary legal shield for Black, Latino, Asian American, and Native American voters, helping to protect their rights at the ballot box and ensure their voices are heard. The Voting Rights Act ensures that democracy is a reality for all Americans, not just a promise on paper, and continues to shape our nation's future. On November 7, 2025, the Supreme Court is hearing a case that could reshape voting rights in America, Louisiana versus Calais. The outcome of this case could have far-reaching consequences, not just for Louisiana, but for the entire country. After the 2020 census, civil rights groups sued Louisiana, arguing its congressional map diluted Black voting power. Although Black residents make up about 1/3 of the state's population, they are a majority in only one of 6 congressional districts. Advocates say this underrepresentation silences Black voters and undermines fair elections. A federal court ordered Louisiana to draw a new map with a second majority Black district. But some white voters challenged this order, claiming it amounted to unconstitutional racial gerrymandering and violated their rights. The Supreme Court agreed to hear the case. But instead of focusing only on Louisiana, the justices asked a sweeping question. Is it ever constitutional to consider race when fixing voting rights violations? This question could affect how every state draws its maps. This challenge strikes at the very foundation of the Voting Rights Act, which for decades has required considering race to remedy discrimination and ensure equal access to the ballot. If the court rules for a so-called race-blind approach, enforcing the Voting Rights Act could become nearly impossible, making it much harder to address racial discrimination in voting. Civil rights advocates warn this could be another major blow to voting protections, following the 2013 Shelby County decision that gutted the pre-clearance requirement and weakened oversight of discriminatory laws. Now, Section 2, the main tool left to fight discrimination at the polls, is at risk of being severely limited or even rendered ineffective. The final ruling is expected in June 2026, but the stakes are already clear. The decision could set a precedent for decades to come. The outcome could fundamentally redefine how America protects voting rights, shaping the future of democracy. The nation is watching closely. Louisiana versus Calais is a battle over what equality means in America. One side argues for a colorblind constitution, no government action based on race, ever. They claim drawing districts to help minorities elect candidates is itself discrimination. The other side, rooted in the VRA's history, says ignoring race perpetuates inequality, especially where voting is racially polarized. The VRA was designed to ensure minority voters aren't packed or split to weaken their power. If the court adopts a strict, race-blind rule, Section 2 would be gutted. Challenging discriminatory maps would become nearly impossible. The current standard allows lawsuits based on discriminatory results, not just intent. Removing this would leave minority voters with little recourse against sophisticated gerrymandering. A ruling against race-conscious redistricting would set a national precedent, giving states more leeway to draw unfair maps. The future of fair representation hangs in the balance. The VRA's impact is real, lasting, and measurable in communities across the country. In the 1980s, Los Angeles County's all-white Board of Supervisors cracked Latino communities across districts, denying them fair representation and a true voice in government. In Garza versus County of Los Angeles, the court found this violated the VRA and ordered the creation of a new Latino majority district. Gloria Molina's 1991 election broke a 115-year barrier, powerfully showing how the VRA transforms entire communities and inspires hope. Her presence brought new priorities, fresh perspectives, and gave a voice to those long ignored by the system. This story has played out nationwide as the VRA opened doors for Black, Latino, Asian American, and Native American voters to participate fully. The law has made government more diverse, more inclusive, and more responsive to the needs of all. The VRA's legacy is one of empowerment, progress, and real, lasting change for generations. If the Supreme Court rules that race can't be considered to fix VRA violations, the consequences will be swift and severe. The protections that have helped ensure fair representation for decades could be stripped away almost overnight, leaving millions vulnerable to discrimination at the ballot box. State legislatures could draw maps that dilute minority voting power with little fear of legal challenge. Lawmakers would have far more leeway to manipulate districts for political gain, often at the expense of communities of color. After each census, states could pack or split minority voters to minimize their influence. This would make it even harder for those communities to elect candidates who represent their interests. We've already seen this in states like Texas after 2020, where new maps sparked outrage and legal battles over fairness. A weakened VRA would make it much harder to fight unfair maps and discriminatory voting laws. Communities would have fewer tools to challenge injustice in court. Section 2 has also been used to challenge restrictive voter ID laws, cuts to early voting, and polling place closures. Without it, many of these barriers could go unchallenged, making voting less accessible for millions. If proving discrimination requires showing explicit racist intent, most challenges will fail. Subtle but harmful practices could slip through the cracks, further eroding trust in the system. States would have more freedom to pass laws that make voting harder for certain groups. The most vulnerable voters would face new obstacles, and the gap in access would only widen. The Shelby County decision already weakened the VRA. Gutting Section 2 would remove the last major federal safeguard. The ability to protect voting rights nationwide would be dramatically reduced. The fight for voting rights would shift to the states, creating a patchwork of access and protection. Some states might expand rights, but others could restrict them even further, deepening national divides. The risk: a less fair, less representative democracy, where the voices of many are silenced and the promise of equal participation is left unfulfilled. Minority voters have the most to lose if the VRA is weakened. The law was created to protect Black, Latino, Asian American, and Native American citizens from disenfranchisement. When voting power is diluted, communities lose the ability to elect advocates who understand their needs. This leads to underfunded schools, neglected infrastructure, and ignored issues like criminal justice reform. Where the VRA has worked, minority representation has led to real policy changes: better schools, fair housing, and language access at the polls. Weakening the law would roll back decades of progress and make it harder for millions to participate in democracy. The impact is not theoretical, it's already happening in states with new voting restrictions. The VRA's erosion would mean lost representation and ignored communities. The cost is measured in silenced voices and a democracy that fails to reflect its people. Louisiana versus Calais is more than a legal fight, it's bot per sto. On ma perstand, it's a turning point for American democracy. The Supreme Court's decision will shape the strength of voting rights for generations. This isn't just about minority communities, it's about the foundation of representative government. When any group's voting power is weakened, the whole system suffers. State-level battles over voting rights are fierce, but only strong federal protections can guarantee fairness nationwide. As we await the court's ruling, every citizen should pay attention. The future of fair elections and equal representation is at stake. The decision will answer: does America still believe in the mission of the Voting Rights Act? The stakes could not be higher.